In our case, there were so many things that I could have done. The facility had like a 36-page fall prevention policy with all these beautiful like decision trees and things where if they came in with this condition and they have this risk factor, you should do X, Y, and Z. But none of those things were done in our case.
Howdy, and welcome to the show. I'm very excited to have another one of our after action reviews where we're going to do a deep dive into a recent case and an outstanding result. Today, we get to sit down with Karman Guadagni and Kelsey Craven, both from Stebner, Gertler, and Guadagni. They're going to talk about their successful trial, in the Donahue versus MBK Senior Living case. And it's not just one trial, it's two trials because there was a hung jury along the way. Let's go into the second trial. You are trying this a second time. You've gotten feedback from, sounds like 8 out of 12 of the jurors in terms of what the issues were, what some of the hangups were in the jury room. How did you then translate that into the presentation and the theme for the case?
In the first trial, the defense did a decent job at really blaming the pandemic on everything, right? Unprecedented pandemic. All facilities like this were having an extremely hard time with staffing. It's not our fault. We're excused from this. And I think in the first trial, we didn't really tackle that pandemic issue head on as much. And it was more just, they should have done this. They should have done this. Whereas the second trial, it was more of a theme of, yes, there was a pandemic. Yes, it was affecting the ability to staff adequately. However, they still had choices despite those difficulties, and they still decided not to take those choices that would prevent harm. So instead of just saying they should have done this, it was more of a theme of choices, and they just kept choosing the bad choices.
Right. And the other thing that we did differently in the first trial, the defense really was that in terms of the wrongful death cause of action, that Miss Donahue didn't die of the hip fracture, that she died of dementia, and she was going to die of dementia anyway. And they had a very qualified expert, an expert who's a palliative care doctor to testify about dementia. And she did so intelligently. And in the second trial where we pivoted was to have our expert sort of talk about that first and show that, yes, she had dementia. And yes, the process of dementia ultimately leads in death. But where Miss Donahue's life expectancy trajectory before was a sort of a straight line, when she had the hip fracture, it caused an abrupt change in that line. And then their expert really she didn't have anything to say to that. And it would have been incredible for her to say that it didn't, just because Miss Donahue had been walking before and then she became bedbound. She lost a bunch of weight after the injury. She developed wounds from her immobility that she never would have had. And so the lesson we learned was the harder parts of the case in the first trial, we needed to take control of and tackle head on in the second.
You mentioned earlier that in the elder abuse world, fall cases are kind of considered the hardest of the cases. Why is that?
Because everybody knows someone who's had a fall that's elderly, and because no person in long-term care could ever say that every fall can be prevented. I mean, probably the only way to do that is to restrain someone or something, which is terrible. Nobody's going to say that's what should have been done. And so what you have to show, and what our experts testified to and what we showed in this case, was not that they had an obligation to prevent every fall, but they had an obligation to do everything they could to have a fall prevention and mitigation plan in place to sort of account for every possible variable, to make changes anytime there's a red flag that comes up, or to evaluate, and to try to reduce the likelihood of falls and reduce the risk of harm if there is a fall. And if you do those things and you do everything you can and a fall still happens, maybe then there wasn't anything you could do. But in our case, there were so many things that I could have done. The facility had like a 36-page fall prevention policy with all these beautiful like decision trees and things where if they came in with this condition and they have this risk factor, you should do X, Y, and Z. But none of those things were done in our case.
In fact, the person who was responsible for training the staff on that policy didn't even know that it existed. So I thought that was pretty compelling to the jury as well.
That sounds like it must have been a great moment in whatever deposition and whatever cross you were doing.
Indeed.
On the expert side, it sounds like in these types of cases, you have a liability expert of some sort, a nursing home expert, and then there's also somebody that you used to talk about the causation piece.
That's right. So we had a woman who has experience in operation of assisted living facilities. She had 3 facilities that she ran herself as the executive director for a number of years. Christina Flores, and she was great to talk about liability and talk about the standard of care and the failures and breaches. And then we had a physician to talk about life expectancy and cause of death and causation for the injuries.
Another area where I would anticipate things might be a little different in terms of working the case up is selecting a jury. And are there things that you're looking for in jury selection that are different than your standard personal injury case when you're handling an elder abuse case like this?
This is where I'm going to have to say a little bit, it depends. I've never tried a personal injury case. So my whole career, this is the work I've been doing, just like Kelsey. So I don't know. But what we really focused on and looked for was jurors who were or would find themselves in the future in a position to rely on someone else to help with care of their loved one more than anyone else. Someone who's not going to be critical of a decision to put your parent in a memory care facility, but somebody who could see themselves or their parents in Teresa Donahue's position. We had in the second trial a woman who had experience working in that type of facility, who I think was a critical juror for us because she could talk about what the staffing was like and what that job was like and, sort of help where it's not just on the facility day-to-day staff, but the actual management and their decisions. I think that helped. For jury selection in both cases, I used this book. There's a book called From Hostage to Hero by a woman named Sari Delamotte. So we used a lot of her guidance and pointers in terms of kind of getting everybody to agree to standard principles and the basic principles of our case. Like, it's reasonable to expect that if you trust someone to take care of your loved one, that they would do so the best they could, that they would tell you if there was a problem or if they weren't able to do it. Everyone agreed with that kind of a thing. And more of the inclusive than exclusive voir dire, which, is an experiment. The first jury and the second were dramatically different. And maybe Kelsey, you can talk a little bit more about that. But clearly we were much more happy with the result from the second.
How are they different, Kelsey?
I think the first jury was very much more of an individualistic vibe. They were all kind of in their own worlds, and versus the second jury was much more communal. They even organized a pizza lunch together just because they wanted to hang out, and you can just sense that feeling of togetherness with them when you're in the courtroom. And so, we obviously were not in the deliberations, but I would think that because they were pretty much becoming friends at that point, that it made the deliberating process easier because they could have conversations without people, and compromise on certain aspects. Whereas I got the sense in the first trial The jury had some people that seemed to be personality types that don't budge, and don't really care what other people's perspectives are. And so I think that sense of community with the second jury really made a huge difference.
And I think you can tell that too from just looking at the verdict forms in both. So in the first trial, what my feedback was that there were 8 in favor of a negligence finding, but the rest were not. And it could never agree beyond that. In the second trial, it was unanimous or 11-1 on every single question. They were really one unit.
Absolutely.
I think you said that the first trial was 5 weeks long. The second one, roughly how long was it?
Basically the same. We started on March 1st and we got our verdict on April 5th. The last day, the jurors were cleared through April 5th, and we had on April 4th got a finding of punitive damages, oppression, and recklessness. And then we had to go home, review all the documents, put on the witness. We had to be done by, I think, 11 o'clock. So the jury would have 2 hours to deliberate, and then everybody had to go. So it was like, we're going to get it done in this time.
Part of the reason I was asking about the amount of time was whether you found there were any efficiencies, like, oh, we shouldn't do it this way, or we can be more concise with some of the information. It sounds like that's not the case, that it was, in essence, the same length.
It was the same length, but I think that we were more efficient in the second trial. In our case, one of the defenses was that the daughter was responsible for what happened because she didn't allow her mom to be on different medications, and then there was also a defense that the hospice who was providing care to Miss Donahue while she was at the facility, that they were responsible for the fall precautions. And so there were a couple of trials within the trial, which were allowed to happen in both cases. And so we weren't totally done. I mean, we weren't totally in control over the timing of things. But in the first case, I think the plaintiff's evidence was like 2.5 weeks. And in the second, it was probably more like 2.
And the question that I was starting to ask was whether you had the same trial judge for both trials.
We did. The judge in our case was Judge Oscar Pardo. And interestingly, the defense counsel in the case, the main defense counsel is a gentleman named Tom Beach. His brother is named Max Beach, who also practices on the defense in this type of cases in Santa Rosa. And Max Beach's former partner was Judge Pardo, who retired and went on the bench. When we were at the first, getting ready for the first trial, we actually had been assigned to a different judge, Judge Broderick, who we worked with in the past on the Sonoma fire cases. And we were happy with him. He was set for another trial. And so we didn't know who we were going to end up with. And then we got assigned to Judge Pardo, and it's kind of had to do a gut check about whether we were going to take this judge or not. But we ended up taking him, and he was very thoughtful, kind of newer to the bench, but he really did what he could to get it right. And he was a judge in both trials.
Some people describe Sonoma County as being very much, there being a hometown advantage, being a somewhat insular bar. It sounds like that was not a problem for you in terms of the way your case came out.
Well, I think we kind of maybe played to the hometown advantage a little bit. So the defense firm is from Southern California, and Kelsey and I are very much Northern California girls, shall we say. We drove every day, Kelsey in her Subaru and me in my Volvo. You know, we were commuting back and forth, especially during the second trial, every single day. And the defense showed up in their rented Escalade with their blue matching suits, very, Southern California. And we were not that. So I think in a way we took advantage of the hometown advantage here.
Was there any moment in the trial where you felt like the tumblers had just fallen into place? Like the evidence for the cross-exam or some piece, it just felt like the jurors got it and things were more likely to turn out the way you wanted this time.
What comes to mind for me is actually further along. It was in the punitive damages phase. And Karman was asking the president and CEO of the company, you said that these would be the documents that would prove your financial condition, yet those weren't produced. Why were they? She was just asking him, why didn't we get all this information? And then on top of that, we also did have a document that showed that, this whole time the company is claiming that they were poor, they were throwing out all their financial resources to get as much staffing as possible. And then we showed them a document showing that they were transferring $2 million a month to their real estate investment trust company. And I just remember the jurors' reaction for that. And when Karman asked the president about that, he basically was just like, I don't know, that's normal. He didn't seem to care at all. He didn't have any empathy or regret for what had happened. And I think that really infuriated the jurors. And I literally heard them scoff. They basically laughed in his face because he was being so defensive and just getting caught in these lies. That was, I think, one of the highlights for me of just the jury just seeing how, pardon my French, but foolish they were. Yeah.
And I'd say too, in the first phase of the trial, there were certainly times where it didn't go exactly how we wanted. There was a witness of staff from the facility who we had deposed, and after the deposition, we kind of learned that she was a lot more involved in things than we knew at the time. We wanted to put her on the stand in the first trial, and they said she's unavailable. And we wanted to put her on in the second trial, and they said she can't. She basically was having like some mental health issues. And so there was a big fight about that and whether we could put her on. And we ended up having to do like an outside the presence of the jury, the defense lawyer had to go to her, and then she was on Zoom, and the judge could ask her some questions kind of about her, whether she was able to testify, and the judge allowed her not to after she finally got a doctor's note. So that was something I felt was really important because she was the staff who was there at multiple of the falls, and she was one of the staff who had given our Miss Donahue lorazepam multiple times. And so she was like someone key. And after that, not being allowed to bring her in, I was kind of feeling down. But quickly we sort of pivoted and picked up the pieces and just tried to focus on and hit the hardest things and really keep it simple. And I think over time in the days following that, it did start to feel like we were getting traction, getting momentum. And that was around the time I started to notice the juror cohesion. So, whatever it was, they were going to be one way or another. But I felt like we were getting our momentum at that time.
When you say juror cohesion, can you unpack what you mean by that? What were you seeing?
Yeah. So when we would wait in the hallway for the judge or the bailiff to let us in the morning or at lunch, we would just see like Kelsey said, they were all planning. They would come and eat lunch together. The courtroom's right across from Mountain Mike's Pizza in Sonoma. They rented the party room, like actually, to have this pizza party. They would all chat and talk about each other's kids, and it wasn't just everybody staring at their phone. They were all like friendly and checking in. And one woman got sick or something happened, and so we had to call an alternate in. And it was like everybody was so concerned for her. You could just tell like they actually were a group. And then once we started to, we had really tried to identify who were going to be the leaders in what year. And they did, there was a sleeper leader in there that we didn't know who ended up being the foreperson in the second trial. but the other leaders were like these kind of stronger women, older women, and they kind of led the dynamic, but the whole group worked together and seemed to work together really well.
When you say sleeper leader, I know when people are picking juries, they're very concerned about who the leaders are and who aren't. How did it transpire that this person, I would use the phrase snuck by, but what do you think made it so that you were not able to identify this person as a leader early on?
There was a juror who he was a tech guy. He pretty much wore a hoodie during trial. He was one of the least engaged with the group. He wore this blue hoodie every day, just kind of kept to himself. He wasn't like totally off, but he wasn't in the middle of things. He wasn't ever planning the pizza party. He took notes, was really serious about everything, but more reserved. It turned out that he was the foreperson. I think he had been involved in some litigation in the past, which we really didn't know about, where I think his home may have burned in the Tubbs fire. He ended up being one of the strongest jurors for us. It wasn't somebody I was even able to speak with after. He didn't really want to be involved after. He led everyone. And when they got to the decisions about damages and stuff, I think he put suggestions out there and everyone accepted that.
If you're enjoying what we're doing here with Cooper's Code, please help us extend our reach by giving us a 5-star review on Apple Podcasts and consider sharing an episode with a friend. Additionally, we want to know who you want to hear on the show. Have an interview suggestion? Email us at podcast@coopers.law. Going back to your witness who the judge ultimately forced you to use the deposition, had you had the opportunity to do a videotape deposition for that, or did you have to read the transcript?
We did. Thankfully, we had video of almost all the depositions because it was the beginning of the pandemic when we were doing all these Zoom depositions. So everything was on video. Again, there were a lot of questions in hindsight that we wish we would have asked her in the deposition that we didn't. But it sort of played to our hand because they were saying, well, we asked the judge to say that she was unavailable for health reasons or something specific. He told the jury she can't be here because of her health. So we're going to play her testimony. But even in the deposition, she was sort of like erratic and all over the place. And I think the jury got out of it that this woman that the facility had put in charge of all these elderly people, including Miss Donahue as like the decider, the manager on duty, was maybe not the best call.
On the technology side, when you're doing videotape deposition presentations or just the technology of trial itself, do you use an outside agency? Do you do that yourselves? How do you tackle that?
The technology is provided by none other than Miss Kelsey Craven. I'll let you speak to that.
I mean, pretty much everything was in-house between Karman and I for all of the things. But technology-wise, with the deposition video, I do have experience with video editing, and so I made the video of the clips that we wanted, so that all we had to do at trial was press play. And so that was smooth sailing in terms of the technology throughout the trial. We had iPads and we're using TrialPad, which I really liked. And I think, it was quite a contrast between Karman and I with our iPads. We had an Apple TV, so we're completely wireless. And then the defendant's table had wires everywhere, like throughout the whole courtroom. And a lot of the times their technology wasn't working, even though they had not only their 2 attorneys, but they also had a paralegal, and sometimes they even had more support. So I think in terms of technology, we were definitely more advanced throughout the trial than the other side. And for example, in closing for the rebuttal, I just quickly put together a PowerPoint on the iPad while they were doing their presentation, so that we just pulled it up, and just had it immediately available of what they literally just talked about. And I think that worked really well.
Other quick takes in terms of things that you did or didn't do. Are you a mini opening person or a neutral statement person?
He did a neutral statement. I don't know if I'm opposed to a mini opening, but I'd never done one, and I didn't really want to try something new on these trials. So we didn't do one, but we did talk about all of our tougher facts in voir dire.
Juror questionnaire?
We weren't allowed to have one in the first trial. The judge said no. He would ask certain questions that we all had agreed upon. Once it came out, though, that one of the jurors had a convicted felony, we said we are not leaving without a questionnaire, and it's got to ask that specific question going forward.
This goes back to finding out that the foreperson in the first case had not disclosed significant information.
Correct.
That's certainly a nice thing to hang over a judge when you're asking for your questionnaire.
There was
the second
really no
time.
discussion.
Yeah. I know you had the very expensive 5-week focus group for the first case. Did you do any sort of focus group for either of the two cases outside of that?
We did. We did a focus group in Santa Rosa before the first trial, where we did it in a court reporter's office. I put on the plaintiff's case, and then my partner, Catherine Stebner, put on the defense. I think we got from our jury an okay verdict, a fine verdict. Was no runaway. And then we did not focus group it again between trials.
Do you use a jury consultant?
No. On the second trial, because of everything, we tried as much as possible to streamline and avoid expense where we could. We didn't use a jury consultant. We just sort of workshopped and talked to a lot of people and then went with our guts.
Did you have an opportunity to talk to any of the jurors from the second trial? And if so, were there any learnings that you got from them that were very helpful for you?
Yes. I talked to a lot of the jurors in the second trial. I think there were only a handful that we couldn't reach, maybe 3 or 4. When the defendants filed their post-trial motions, we knew that we needed to rule out any, juror misconduct. And so we got on it really quickly. And I talked to everybody very in depth. We did get information, one of the most insightful people that I talked to was the juror who was the one against us on a couple of the things. She was very conservative. And she just wasn't a big believer in lawsuits. She worked for a bigger company. She didn't feel like it was overwhelmingly neglect or anything like that. I don't think she found negligence, but some of the more corporate stuff, she did go with us. So, I think we really tried in the second trial not to stereotype or try to put people in the same boxes and make assumptions about where they would end up, and tried to get people that had the right value system and valued elders. It's a hard area for people to give pain and suffering, and for people to find wrongful death when someone's in their 80s. So that's a challenge. And you really have to finesse to find the jurors that are going to be open to that conversation. So I sort of veered away from your question. But we did learn a lot talking to the jurors, for sure. I'm trying to think of like a main takeaway of something we learned, but more that people aren't always black or white. Like this one conservative person, she was with us on certain things, which I didn't expect her to be, but not on the negligence question, which seemed to me the easiest one.
Yeah, I think there's a mentality that if you're older, then you're more likely to be on our side in terms of elder abuse cases. But, she was a prime example of how, again, stereotypes and assumptions don't always play out when it comes to jury selection.
Sometimes in that hang time between the initial verdict and the punitive damage phase, defendants start scrambling and trying to figure a way out. Were there any talks between the time that the initial verdict came in and the punitive damage phase?
Sometimes when I'm doing deposition prep, I'll tell certain clients to answer the question they wish they'd been asked. So that's what I'm going to do. So actually, there really was a time between the first verdict and the second, because we literally, I think they came back at like 3:00, and then we had to drive home and review the documents and put the witness on the next morning at 8:30. Drive back to Santa Rosa. But after the jury went out in the second trial, during that 2.5 days, we were getting emails from the other conference room from the defense. Our carrier thinks it's going to be another mistrial. We should talk about settlement. And we were like, well, we're not really interested. And then they said they think it's going to be another mistrial. They really feel it's going to be another mistrial. And we said, well, we're open to it, but you got to make, now's your time. And they didn't really offer anything that changed our mind from finding out the outcome. And I really do think our client was looking for, shouldn't care about the number, but she was looking for the jury to say, yes, you were right. They didn't do what they should have done when taking care of your mom. And she got that. And that is more valuable than anything else for her at the end of the day.
Any other learnings, wisdom pieces that you would like to share from your experience in this fight?
I had a little bit of a rough time processing the hung jury the first round. This was my second trial. The first trial settled after jury selection, so it was my first full-blown trial. And it was a big knock to my ego to get a hung jury. And then not only to not win, but then to be like, oh my God, we're gonna have to do this again. was just a lot mentally. And I think what I learned from this experience is that there's a certain type of mindset of when it comes to not meeting what you put your own expectations for yourself, to just not be so hard on yourself, and there's always positives even when you do lose, right? It's a learning experience no matter what. Still got trial experience, still learned an insane amount that forever changed my career. And so I think for me, of just pivoting on the way that you process non-successes, I don't want to say losses because I don't think that's the right word, but of just keeping hope and just keep doing the good fight, because that's what we're all here for.
I really like that, Kelsey. I have some big and small picture, I guess, things. So smaller picture, like actual trial things. I think what the process showed me is, even throughout the first trial and then the second trial, we were still learning things. When we looked at the same information again, we were still realizing new things or figuring out different angles. And you always have to be open to that. And don't just start with this box. This is the discovery we have, and this is how we're going to put it on at trial.
Mm-hmm.
Without being reckless, it's okay to sometimes start down a road you don't know where it's going to go, because it might end up for you in a really good place, which is what it did in this case. Bigger picture, I think my coping mechanism is a little opposite of Kelsey, because I don't know, mine was just Energizer Bunny. So as soon as we got done, I was like ready to go. And everybody else is like, what are you doing? Maybe you should settle the case. What are you doing? And I was like, nope, we're going, like, I'm getting this. I know we can get it. Don't give up. Part of it too was our client was just really, she and I were in lockstep in that mentality. We were really lucky to have great clients who we had a really good relationship with, that we really trusted, and that really trusted us to go in there and do our best, and then let the chips fall where they lay or where they may. And so we were really lucky. And I know we won't in every trial have that situation, but we did here. And then I think too is like, you never know what you can do, what challenge you can meet until it presents itself to you. I mean, it was certainly a challenge. There were times in the second trial when Kelsey was working on another trial where I was by myself in court against these two guys with all their support and their wires and everything else talking about medicine and, putting on experts or whatever. And that was hard. And then driving home at the end of the day and picking my kids up from school and doing home things and then prepping and then going back again and again for 5 weeks was hard. But you just got to know that you'll meet the challenge and have faith, like Kelsey said.
Where I was going to close was to ask each of you if there was anything that you wanted to share with people who are in the phase of wanting to become trial lawyers, who are younger trial lawyers. Anything along the way beyond what you shared that you would want to tell them?
I would say, simply put, just say yes, right? If there's an opportunity, even if it scares the crap out of you, just say yes. And, it's kind of a little bit of a fake it till you make it mentality, but I feel like it works so well. And, you'll, again, like what Karman was saying earlier, you'll find a way to make it work. Do those power poses in the bathroom before before you go into the courtroom. I actually did that and it actually helped. Just that yes mentality, I think really will not only get you to have those opportunities that you've been wanting, but will also keep pushing you through once you've had those opportunities.
Yeah, I would say two things. Number one is for newer attorneys is sometimes you really have to push to get your foot in the door to have a spot at the trial table. And it's important to do that. Even if it's a small slice, take what you can get, like Kelsey said. And for more experienced attorneys, I think we all have an obligation to make room at the table and lift people up. It can be a much more secure feeling to know that somebody more experienced is going to handle the trial from soup to nuts, but you're doing yourself in the long term a disservice by doing that. And then I would also say that it's okay, even in trial, even in front of a jury, to be a human. And it's okay to make mistakes sometimes because that's a human thing. And jurors want to see you as human. In my closing, in the second trial, we totally changed the way that we were going to ask for numbers. The numbers, in the first trial, we asked for just a round number, $5 million. In the second trial, it was this crazy number. And so I put it on the PowerPoint. I said, okay, this is the amount we're asking for. It was like $8,643.17 or something. And then I said, okay, I'm going to explain to you how I did it. And then I wrote on the board all these different calculations. It's like the number of days you were neglected, the number of days she had scabies, the number of times she had a fall, the number of times she was medicated when she shouldn't have been. And it all added up. And then in the middle of my presentation, which I hadn't practiced because we just decided it like the night before, the defendants objected about something. A date was wrong. And I had to recalculate. And math on the fly is like nobody's dream, but in front of the jury with everything written down and like my scribbled notes was terrifying. And so I just stopped and I said, hold on. And I redid everything on my phone. I did it with a calculator. I said, I got to check my work because I'm a lawyer, not a math person. And then I went back on and I think the jury found it endearing and the math was right. Like it checked out. And they actually did give us a lot of those weird specific numbers that we asked for. I don't know if that's why, but I'll take partial credit.
I gave it to you.
Well, thank you both for taking the time to sit down and talk about the case and sharing all of the work and the learning that you've had from it.
We really appreciate the opportunity, Miles. Thank you.
Yeah, thank you for having us. It was a pleasure.
And for all our listeners out there, thank you for joining. If you like what we're doing, please consider sharing the podcast with a friend or giving us a 5-star review on your podcast platform of choice. To all of you doing justice out there, happy hunting.